Labas rytas visi. Good morning, ladies and gentlemen. We are starting on time. Let us continue our conference, the unification of the case law of the courts, forms and challenges, and today we will be speaking about other forms of achieving consistent case law. Yesterday we were very much inspired to proceed further. Yesterday we spoke about one of the main tools of unifying case law, that is the adoption of rulings and establishing case law by those rulings. This is true for Lithuania. And in Lithuania, we are still wondering whether we are the country of precedent in law or we have the continental law, irrespective of having the term precedent in our legal system. After the conference, we will consider further on our system in order to improve it. The second part, as we've defined it, we spoke about preliminary rulings, preliminary questions, and we spoke about future perspectives rather than retrospective, and also ways how to ensure that as many issues are being dealt with the Supreme Court. And now we are entering part 3 of the conference. It is not only those two forms that we discussed yesterday are important for unifying case law. Other forms exist, and today my colleagues from Supreme Courts and Professor Aleš Galič will describe those different forms in order to implement our essential mission as the Supreme Court and also other courts. It is a great honor for me, a great privilege for me to give the floor to Professor Dr. Habilitus Aleš Galič from the University of Ljubljana. He's a keynote speaker of our today's part of the conference. He will be speaking on the different ways of ensuring the consistency of case law in civil law jurisdictions. Professor has visited the Supreme Court, and I am sure that you will be able to hear some interesting ideas and some interesting suggestions for further steps. So, Professor, the floor is yours.
Thank you very much. It's not messaging. I'm just setting the alarm clock so I don't speak more than this 45 minutes. It's, I think, right. Important. Madam Chief Justice, honorable judges, dear colleagues, friends, it's indeed a great honor for me to be again here in Vilnius. Somebody asked me yesterday, is it your first time? I said, no, it's second time in 4 months, and fifth time in the last 4 years in different capacities. At university, European Judicial Training Network, Supreme Court. Conference is organized by very active Professor Necrocius especially. It's always a pleasure to be here. Congratulations for the anniversary, but of course, foremost congratulations for the achievement of the Supreme Court in reinstatement of the rule of law in Lithuania in the last 30 years, I'm sure with the very important assistance of the whole legal community, academia, bar, so the lawyers, constitutional court as well. Different ways of ensuring the consistency of case law. But still, I think it's worth starting with this one, namely to remind you that European Court of Human Rights has established the link between the consistency, uniformity of case law on the one hand, and the right to a fair trial under Article 6. of the European Human Rights Convention. And that's the formula. It's a rather recent development, as you see, some 15, 20 years. When do we have a violation of fair trial in this regard? Profound and long-standing differences. So not every single instance of two conflicting judgments, as we discussed yesterday, is already a violation. Sometimes it can be only tolerated. Sometimes it can be good for development of law to allow different ideas to come to expression. And then, and that's our topic, whether the domestic law provides for machinery for overcoming those inconsistencies, and then whether this is effective. Second, there are two situations. One situation, we have conflicting case law and the need eventually, not necessarily immediately, but eventually to ensure consistency or uniformity. The second situation is where we have already uniform case law, but then we have a departure from it. And for this situation, the Article 6 requirement is you may depart if the precedents are not binding. You may depart from the viewpoint of Article 6, but you need to give reasons. Reasons for particularly this point, the point of departure, to show that you are aware that the case law has been different, but you see reasons why this would be good to change. This is a modest requirement, but that actually it's a huge requirement, because I'm quite sure that in most cases when the lower court judges do not follow the case law of the superior court, that's not because they want to make something new, that's because they don't know it. They overlooked it. And this is important. It should be seen from the judgment whether case law has been overlooked or whether it has been knowingly departed from in order to try to settle a new way. And third, the role of Supreme Court is huge in this regard, but if the Supreme Court doesn't fulfill its function, it can, instead of being the instrument for achieving uniformity, become a source of uncertainty and conflicting case law. That can also happen, and that's the worst what can happen. A non-exhaustive list of these cases, you see anything in common? Well, obviously, this is a problem more present in former communist countries and Turkey, which I think it's good to stress, because often I hear, well, this open access to the Supreme Court, that's okay in the Western Europe, but leave to appeal system, selection of cases, precedential, that's okay for the Western Europe. But here we need full access to the Supreme Court. It's actually the other way around. We need to focus, obviously, more on the importance of ensuring this public purpose of the Supreme Court, namely development of law, uniformity of case law. Different ways. Now, we discussed the courts, but there are instruments where courts act in a non-judicial manner. So they ensure uniformity not through judicial function, not through adjudication, but somehow else. And that is, as you see, problematic. Binding interpretational statement, I would say that's a relic from the communist era. Advisory opinions, not very much different, perhaps more fancy word. And this is problematic. Why? Well, first, inner independence of judges. Second, and I think that's more important, separation of powers, constitutional role of judicial branch. Now, I discussed that in one other country recently, and they said, well, how can you criticize these binding interpretational statements? It is our constitutional role, said the Supreme Court judge, to ensure uniformity of case law. Well, I said, if the constitutional role of a court consists of doing something which is not adjudication, which is not judicial function, then we have serious problem in understanding what the role of courts in separation of power is. Courts can have some non-adjudicative functions, but it cannot be their main role. And by the way, third problem, Where are the lawyers? Usually when we have these instruments, lawyers disappear. I mean, advocates, legal counsel. They are not heard. Parties are not heard. This is decided purely in abstract manner. And that should not be the case. Professor Margaret Wu yesterday, I think, very correctly pointed out, don't forget about the role of lawyers in this regard. So, a few words about the, I would say, oxymoron of judicial lawmaking in abstracto, these binding interpretational statements. CCJA, I will mention this interesting instrument adopted by Council of Europe, Consultative Council of European Judges. It's not recommended, binding interpretational statements. Venice Commission criticized Hungary. They had this instrument of uniformity decisions. Now that should be abolished. US Supreme Court, I very much agree. They consistently struck down statutes which would require federal courts to give advisory opinions. It's constitutional role of the court is not to advise, it's to decide disputes between the parties. European Court of Justice, judicial function. Now, and what is court? Well, what is court depends. There are different definitions in different instruments, but certainly judicial function in the view of ECJ, which is important, for example, when can question for preliminary ruling be posed? It's deciding disputes between the parties. And then European Court of Human Rights, on the contrary, surprisingly, but this is one indication that unfortunately the Strasbourg court failed to see the broader picture. It criticized Serbia, which had such a remnant from communist era, that they haven't used it. Without any single word or any single thought that these instruments, binding interpretational statements, are perhaps very problematic. And I learned yesterday and today, and I think rightly so, your Constitutional Court, Lithuanian Constitutional Court, also find such or similar instrument not to be in conformity with Constitution. One more, very recently, Croatia, a veto right of so-called registration judge. If he discovered that, if he was of the opinion that the judgment which was already rendered conflicts with some other judgment of another panel. Now it's okay to, as we heard yesterday, to draw attention, or that the panel itself, like in the Strasbourg court, then refers it to the broader panel, Grand Chamber. But this was, after the judgment was issued, a kind of veto right of a judge who was not a member of the panel. No? Non-surprisingly, ECJ said, no, that's incompatible with Article 47 of the Charter. But before the judgment of the ECJ, Advocate General Pikimäe, I think Estonian, he found that instrument perfectly useful and adequate. So you see, you had a lot of, I would say, misunderstanding in this field. So through adjudication should be the method of ensuring consistency of case law. That's the green light. And by far the most important ways are not preliminary rulings. By far the most important way is to have in place adequate filtering mechanism for access to the Supreme Court. Adequate filtering mechanism which is oriented toward the so-called public function of the Supreme Court. And then, additionally, in order to avoid discrepancies, conflicts in the Supreme Court as well, that you would need to have instruments in the Supreme Court where there is conflict in case law in the Supreme Court, like grand chambers, extended chambers. And as we heard yesterday, preliminary rulings, appeals by public bodies like public prosecutors, but that's not the communist era public prosecutor instruments because it only has declaratory effect. It's only for the future. So you see, yesterday I was critical in a way for preliminary rulings. Here I put them in the green light. I think this is, if it's framed correctly, adjudication. So that's not, in my opinion, the problem. The problem was discussed yesterday. That's this opinion of the Consultative Council of European Judges. It very much reflects what I'm telling here. Not surprisingly, because I drafted that opinion, always Council of Europe invites one academic to assist the judges to write a draft, and then the draft, of course, is discussed in the working group and then in the plenary. And most of things that I discuss here are addressed here. Private or public purpose, to remind you, what is that? Supreme Court oriented to private or to public purpose? Private purpose, ensuring that justice is done in the individual case for the benefit of individual parties. So it's rather retrospective. You look to how the concrete case was decided, whether it was decided correctly for the benefit of the parties. Public purpose consists of ensuring consistency, uniformity of case law, development of law through case law, the precedential value. So it's oriented toward the future, benefit for future litigants. It will benefit the litigants at case at hand, but that's not the major concern. So these are the two roles. Now, we all agree both roles are extremely valuable. What do you do when you have an option? I mean, there are two valuable, good things that are offered. What do you take? Well, I tell you. That's my advice. Take both. Huh? Can you take both? Can Supreme Court fulfill both in its private and public function? Well, in the ideal world, it can. You see, that is Slovenia. How does it look? Everyone enjoys the right to have his dispute in the last instance. So open access to the Supreme Court. But not just open access, but then every case in the Supreme Court is thoroughly discussed, well-reasoned, and correct, I would say. And then there is the public purpose. Case law of the Supreme Court is uniform, no discrepancies, no conflict in case law in the Supreme Court. And then there is this precedential effect. Judgments are published, they are studied, and they are followed. That's how it is in the ideal world. But there is also a real world. And in the real world, it doesn't work, except if the country is very small. And very small, I don't think, I mean, Slovenia and Lithuania are already way too big. I think countries like Liechtenstein, Iceland, perhaps. Otherwise, what happens in the real world is, if you have unrestricted access to the Supreme Court, presumably in the private interest of the parties in doing justice in every individual case, it's a big caseload. But then you have a high number of Supreme Court judges, less esteem in the public opinion and in the legal community, and inevitably also conflict in case law. Italy, open access to the Supreme Court, 30,000 civil cases per year, 300 judges. In Italy, there are more Supreme Court judges than train drivers. It's not particularly esteemed profession anymore. No? That also matters. Thousands of cases decided, but many of these cases bring in nothing new, just lawyers copy-paste their previous appeals, and the Supreme Court copy-paste their previous judgments. So nothing new, no added value. But there are novel cases, but then they are overlooked, or because under great caseload, they cannot be devoted much sufficient time. The worst thing that happens is that when the Supreme Court cannot follow its own case law, and you have inconsistencies within the Supreme Court. And the lower courts, if the output, that's often forgotten, if the output is too big, the lower courts cannot absorb that, cannot follow it. It's too much. No? And outcomes are unpredictable. Attorneys cannot give clients reliable advice. As I in Slovenia previously said, what do you think? Well, I don't know, it depends. It depends what panel you will get. No? And that's all presumably done in the private interest of doing justice, but the result is totally different. We attempt a reform. Why not have more Supreme Court judges? Well, you will manage the caseload, but you will increase the problem of conflicting judgments in the Supreme Court. The other filtering criteria, value of claim, you can lift it up. You manage the caseload, definitely, and the output. But you prevent many cases, not as we heard in the Netherlands and Finland, by informal filtering, but by formal filtering to reach the Supreme Court. Value of claim, consumer cases, most of them will never reach the Supreme Court. That's the bad filtering criteria. So our conclusion is no better about the programmatic proclamations. If you open door to the Supreme Court wide open, the public function will inevitably be lost. So it all matters on this person. The selection criteria. And there are, as you can see, there are different selection criteria, and that is important. And this is not primarily about reducing backlogs. I think this is another misconception, misunderstanding, often somehow hinted also by the ECJ and Strasbourg Court, that this filtering mechanisms, leave to appeal system, that's okay for efficiency, but otherwise it's not desirable. No, it's not only about efficiency, it's about better doing justice in this public purpose oriented, which is also human rights requirement. Which court and in what kind of procedure? Now we discuss granting leave to appeal. Well, there are different ways. Supreme Court in two steps or one step from the viewpoint of the, but I'll skip that. The flags, of course, this leave to appeal precedential value, would say, well, that's common law, it's UK, it's USA, Canada. It came to Europe via, as many things, not via Scandinavia. I don't know here whether Norway or Sweden was the first, and then Finland followed. And then from Scandinavia, that went to Germany and Austria, and I think that is now the worldwide trend. It's not genuinely embraced by everybody in the legal community, especially not by practicing lawyers. See two quotes. Slovenian lawyer, practicing lawyer, if you kind of close doors to the Supreme Court, that will inevitably cause arbitrariness and violation of human rights in the lower courts. I must say I never understood the logic. If there is no appeal, there will be inevitable violation of human rights and arbitrariness. Because what about then the higher court? There is a court on the top against which there is no appeal. So then, if this logic stands, then you would have the Supreme Court or the ECJ inevitably acting arbitrarily. In Germany, long time ago, dark ages where individual interest didn't matter. That's a clear hint to Nazism. Yeah. But see, that's easy to claim, they open doors, but the results would not be for the benefit of the individual at all. If this logic was true, more open doors to the Supreme Court, more judgments of the Supreme Court. If that logic was true, then what would be the answer here? Italy, 30,000 civil cases per year. UK, 100. Or Sweden, 100, Finland, 100, Estonia, 100. If the logic, open doors, more justice, better justice, more uniformity, was true, what would that mean mathematically? Well, it would mean that in Italy it's obviously 300 or 400 times more uniformity, consistency, and quality and justice than in UK or Sweden or Finland. I guess that's not true. If you have unrestricted access, you will result in case law of the Supreme Court looking like this. Conflicting. One Italian professor, Chiaroni, once wrote, case law of the Italian Supreme Court is like a supermarket. Every lawyer can find what he needs for both sides, yeah? And that doesn't guarantee any predictability. Yesterday, Professor Verkerk said, what was the expression? It was a fancy expression, information overload. I put it a bit differently. The problem is when you get a situation where nobody can actually find anything anymore, like a typical law professor's office. I think it's a matter of simple logic. If you have a problem in the lower court and you think you will not solve it by opening wide the doors to the Supreme Court, you will just transfer the problems in the lower court to the Supreme Court. But even when legislative reforms promoted public purpose of Supreme Courts are implemented, they are sometimes blocked by constitutional courts. This leave to appeal system. What is the battleground? The battleground is this. Does the decision of the Supreme Court denying leave to appeal need to contain reasons? Now, where it all originated, USA, UK, it's clear, no, it's an integral part of the system. Again, kind of a logic. It's logical. You select cases, you would achieve nothing if then in the cases which are not selected, you also need to decide them somehow with reasons. I was once in Uppsala discussing this with Professor Per-Henrik Lindblom, which I think is the biggest authority for these issues still in Europe. He said, well, this private-public purpose, when we were introducing the reform in Sweden long ago, we had all this discussion. But he said now it's a kind of consensus that the reform was needed and that it was successful. But he said, I can understand the dilemmas. But what I cannot understand is that you implement the reform, you decide we will select cases, but then impose obligation that also for cases which are not selected, you need somehow to decide them by providing reasons. But that's Sweden. Eastern Europe, many countries' constitutional courts have quashed the reform, effectively quashed the reform by saying, no, you must, for the cases non-selected, cases denying leave to appeal, you need to provide reasons. Two typical formulas to prevent arbitrariness and right to reason judgment, right to be heard. Armenia, Poland, Croatia, Hungary, I would say quite astonishingly, position of the Constitutional Court, assertion of violation of law should be sufficient for admissibility of any appeal. So no filtering criteria at all. You remember Council of Europe, these uniformity decisions? That's how they did it then in Hungary. We need to decide every case, but precedential value is lost, so we will use these communist era uniformity decisions as the substitute. That's not the good way. Czech Constitutional Court, if you don't give reasons, you negate the private purpose. I think the Czech Supreme Court correctly states that. But the problem is perhaps the assumption that the private purpose should be the one which is prevailing in the Supreme Court is wrong. You need to put this also in the broader picture of sometimes conflict in relation between Supreme Court and constitutional courts, especially where you have constitutional complaint against judgment, which you don't have in Lithuania. That's where the constitutional courts say, no, no, we are on the top, we can select cases. You, Supreme Court, you are below us, you are still the production bed. That's how you work, you should work. You cannot select which box you will work on. No? Slovenia, we also had the same battle, but a different result. We adopted the Swedish approach, no reasons. And they said it's an integral part of the leave to appeal system. If this falls, everything falls. It's not to make life of Supreme Court judges easier, to make them lazy. It's, well, fully concentrate, work more on the cases selected. They will have precedential values. Professor Margaret yesterday said, if you have precedential values, then you should really work hard on those cases. Manage an amount of decisions. out of Supreme Court, that it can be properly followed. You know, case law of the Supreme Court is, how should I say, it's like Keptinis, like Lietuviškas kaimiškas alus. It's great, it's excellent. But there is a limit how much you can properly absorb. At a certain point, it's too much. And then the effect goes, I mean, it's, you know what I mean. Third, no reasons is also necessary in order not to create impression that the Supreme Court, by denying the leave, somehow confirms, upholds, agrees with the lower court judgment. Again, recent judgment of the ECJ, tremendous error, I would say, where they kind of presumed that if the Supreme Court, Slovenian Supreme Court, denies leave to appeal, kind of upholds the lower judgment. That is not true. So, well, it's 5 countries and only Slovenia, but what our approach is in line with what is in the West. No need to provide reasons, you see the flags. European Court of Justice, it's not a human rights requirement to provide reasons in these no leave to appeal systems. However, again, the Strasbourg Court says, but if the country introduces the need to provide reasons, that's the expression of a higher standard of human rights protection, which I think it's not. It's, in my opinion, that's another indicator that the Strasbourg Court doesn't see the broader picture here. Kind of animosity toward leave to appeal system. Kind of perhaps it's okay for efficiency, but it's bad for the quality of justice, which is, I think, wrong. Other methods, informal, indirect, we'll discuss that. But one point, civil and common law are certainly converging in this field. Reforms of access to the Supreme Court, filtering mechanisms, and the link of European case law with the right to a fair trial. Stereotypes are not only on this side of the ocean, they are also on the other side of the ocean. How the common law lawyers perceived civil law countries. Citizens, it's not very old, it's not from the 19th century. No? Common law lawyers. In the civil law systems, case law is irrelevant. Irrelevant. Now, if you look at the filtering criteria for the access to the Supreme Court, we've seen them from Finland yesterday and Germany, and this is Slovenia. Huh? The filtering criteria, important question, which will contribute to ensuring certainty, uniform application, law, development of law. If you have such filtering criteria, there is an inherent expectation that this will matter for the future. It will be relevant. It is expected it will be followed. Slovenian Supreme Constitutional Court said, didn't shy away for stating the role of the Supreme Court is to create precedents. Print screen from the Finnish Supreme Court, it also said, our role is to create precedents. And that's not preliminary rulings, they were not in place when I made the print screen. It's this filtering mechanism. There are still points of difference. First, may a lower court depart from the case law of the higher courts? Common law we heard not, stare decisis not. I would say in continental Europe mostly yes. There is this fair trial requirement. If you depart, you must provide reasons, but you may depart, but provide reasons. But as I understand in Lithuania, there are binding for the lower courts, which I'm not sure it's a good idea. Secondly, don't forget, it's not only Supreme Court, it's also appellate courts which create case law. And the uniform case law can accumulate on the level of appellate courts. If it does, then of course it matters. Then the judge who would want to depart would need to provide reasons. Second, do you need one precedent or a line of precedents, kind of Jurisprudence konstant ständige Rechtsprechung? That was traditionally point of difference. That's from Louisiana Supreme Court, which is interesting because it's a civil law country in the USA, civil law state in the USA. But this difference is diminishing. Now when you have selection criteria of creating precedents, of course it's enough to take one. It's not that now we will need to take 10 cases, so we show that we have a jurisprudence constante. Yesterday I mentioned, and here is the quote, Justice O'Connor, US Supreme Court, it's not always good to immediately ask for the intervention of the Supreme Court. Not only is immediate achievement of uniformity not always possible, it is not even necessarily desirable, as the resulting divergence provides us valuable moment in law, moment of dialogue among jurists. That's the dialogue. No? Let the different ideas compete. Who guarantees that the first shot was the best shot? Where are judges more eager to follow established case law? Civil or common law? I would say stereotypical, I would say, well, in common law it's binding, yeah? Well, on paper, but it's an interesting book. It's a Swede who then had a career both in Sweden and USA. That convincingly shows research that actually in the civil law countries, judges are even much more eager to follow jurisprudence of their highest instances. The other question is whether they have knowledge how to properly follow. Case law analysis, distinguishing, but they are very eager to follow if they know the case law. The reasons is that the pressure on the judge to follow established case law is immense. Institutional pressure, peer pressure, your colleagues. If you don't follow, if you want to reverse, it's possible that the higher instance will not agree. There will be numerous reversals, loss of prestige, extra work. It's easier just to copy-paste from what has been decided before than to try something new. Qualitative standards for evaluation. How many of your judgments have been quashed? More than this colleague, he will not be promoted. He will be. I would say this is sociological, this is not law. But until we have judges like that, these sociological issues matter. Martin, you also have professors like that in Leiden. You know, if you want to do it something differently than other panels, your colleagues won't like you. You will soon walk around the court not in the robe, but like with this T-shirt. I have a friend who is a judge, and he often tries something new, and he's very diligent. He was kind of, he must have spent 2 weeks working on that. Try to perhaps do something different or to set a new course. And I asked him, but what do your colleagues tell you when you have these meetings in the court? I say, most often I hear, be a team player. If you're not a team player, that's not good. No? It's lose-lose. Your colleagues won't like you, you will work more, and it's extra work because the appellate court might quash it because they don't agree, and your prospects for promotion will be lower. So, another point, do Supreme Court judges have an important say in deciding who will be a new judge appointed to the Supreme Court? It's about this. And we have the discussion, I think, very dangerous. You know, well, we tend to prefer people who agree with us. But that's human. So it's possible that if this is the case, not the best lawyers would be selected, but those who were most conformist, who only copy-paste the judgments of the Supreme Court, who didn't try to somehow challenge the views of the Supreme Court. That's, perhaps it depends on the country, on the legal culture, self-perception of judges, but at least in Slovenia that was a problem. I'd say, should the Supreme Court or some other body, it's a judicial council, have the major say? The next one, I told you about this instrument opinion of Consultative Council of European Judges. There was a questionnaire. Questionnaire was prepared by somebody else. And one of the questions was, what are the consequences if the judge doesn't follow the established case law? What are the consequences? And I went through the answers. Again, former communist countries, typically, and in very rigid manner, that will negatively affect the judge's chances for promotion. Georgia, Bulgaria, Montenegro, Armenia, Romania, Serbia, even one step further, there will be disciplinary sanction if you do not follow case law, disciplinary offense punishable by law. I said, wait a minute, you got it all wrong. I mean, it depends. If the judge is reckless, he doesn't study, he doesn't know the case law, that should be a ground for a negative evaluation. But if he tries to set a new course to change the case law, showing that he knows how the case law was before, but that it's time to change it, in his view, that should not be considered something negative. This is Lord Denning, perhaps you heard. He never made it to the Supreme Court, but he was Master of the Rolls, President of the Appellate Court of Appeals. And he was famous because kind of making waves. He brought many new ideas, many fresh perspectives, sometimes successful, often not successful. But it's generally, I would say, accepted in British legal community that he had a positive role with his inventive style, making waves. Lord Denning was from England, and that was good for him, because if he was a judge in one of these countries, he would spend most of his career reading negative evaluation reports and perhaps sitting as defendant in front of some disciplinary committees. From the same questionnaire, but again, different part of Europe, I think Swiss Supreme Court Federal Court judge who got it right. But no, judges are not held responsible if they don't follow the case law of higher courts, if they give good reasoning. That's not negative. They may even contribute for the further development of case law. But that is Switzerland. Now you decide, you prefer those countries or this approach. Problem number 2 is precedent perceived in a quasi-normative manner, trying to extract from it as abstract as possible. Yesterday we heard maxims, sentences, summaries. That's how we like it. Okay, in US they also have these maxims, but that's just the first step. Then they go to study the case. We like to see precedents in a kind of quasi-normative manner, and that can result in errors. In errors that you stretch the precedent to the cases which do not really fit. And as I said before, judges are actually eager to follow. The problem is they might follow where they should, although the case is different, which could be established at the closer look. It starts in law schools, typical American case book. I thought, what a waste of time. 200 pages, 20 judgments. I thought, admit, when I was a student, what a waste of time. We also deal with precedents, commentary of one Slovenian law, commentary, and that's how it looks like. You see, we are very efficient. 1 page, we deal with 18 precedents. The Americans spent 300 pages for that. But of course, this is not how a case analysis should be. And now, because it is approaching the end, I will just point so leave to appeal system, public purpose oriented, that's good, I think. But there is a major blow coming to it, possibly, at least for questions of EU law. A recent judgment of the ECJ in Kubera case where this leave to appeal system of the Slovenian Supreme Court was put under test. But you say, well, okay, it's Slovenia. No, Slovenian system is exactly the same as Finnish, Swedish, German, Austrian, almost the same as Latvian, as Lithuanian. The Slovenian government here defending was joined by the Dutch government, by the Latvian government, and some else. On the face of it, it brings nothing new. It's just a reiteration of Zielfeld and consortio criteria. If the highest court, Supreme Court, does not refer, it needs to provide reasons. So nothing new. Even for leave to appeal system, that has been said in Lyckas-Skog's cases for Sweden, and Swedes then introduced the law that for the leave to appeal, denying leave to appeal, there would be need to give reasons, but they are very formulaic, as I understand. Perhaps you could comment that the Zielfeld criteria are not Zielfeld criteria, so that it's not that either it's already acte clair or acte déclaré have been checked. But I don't say anything more. But what actually the ECJ said, it's not about reasons. You know, if you say, you have to tell us if it's A or B, but you may not say it's B, then it's not a problem, then it's not about reasons, then it's about substance. They say, you may not say that the question of EU law is not an important question, and you must grant leave to appeal whenever there is a controversial question of EU law involved. And for the cases where you think that it's either acte clair or acte déclaré, the decision denying leave to appeal must contain reasons. So, huge change of how we used to deal with cases. And I would say huge change as to how now questions of EU law and questions of national law are treated when it comes to selection criteria. EU law now is privileged. It's a kind of principle of equivalence turned upside down. That's the 43 minutes. I will stop just to elaborate, not to elaborate, just to finish this thought. For the questions of national law, which could be extremely important questions, surrogacy or compulsory treatment of psychiatric patients, or civil procedure issues, all civil procedure issues of national civil procedures, are important questions, but they don't necessarily pass the test of this fundamental importance. But every question of EU law which is not resolved must pass the test automatically. And if it doesn't, then you need to provide reasons. So which means in practice, you need to deal with all cases. Even with cases where the lower court said, no, this is acte clair or acte déclaré, the Supreme Court must say it, must explain again. The crux of the error, and that's the last one, Advocate General Emiliu Incubera, in the leave to appeal system, such as in place in Slovenia, decisions of lower courts are, when the leave to appeal is not granted, upheld by the Supreme Court without any verification as to whether their interpretation of EU law was correct. Upheld, denying leave to appeal equals upholding. In French, confirmer, bestätigt, patvirtina. And I checked, patvirtina confirms, approves, verifies. That exactly is what the decision on non-granting leave to appeal is. It is not accepting, confirming, even indicating. And again, the US Supreme Court, the denial of a writ of certiorari imports no expression of opinion upon the merits of the case, as the bar has been told many times. No expression of opinion upon the merits of the case. The bar has been told, unfortunately the ECJ hasn't been told. Different from Italy, consortio, Zielfeld, the Italian system, the French system, even the Dutch system in origins it kind of means if the Supreme Court doesn't accept it, that it agrees with the decision, because in Italy, every violation of law, or in French system, would be a ground for cassation. But that's not the case in leave to appeal system like Sweden or Slovenia or USA. And in Sylphid, that's correct. If they don't give reasons, if they don't accept it, they kind of confirm it implicitly. But not in the real leave to appeal system, where the selection criteria has nothing to do whether the case was correctly decided or not. And so much about mastering the technique of distinguishing in the ECJ. Sorry for exceeding a bit the time. There would be more, but thank you for your attention.
Thank you, Professor. Thank you for sticking to the time limit very precisely. Dear participants of the conference, you saw that Professor has elegantly combined yesterday's and today's discussion and the issues that were touched upon and that are relevant for Lithuania and discussed on a daily basis. The function of the Supreme Court, finding the balance between the private and the public function of the Supreme Court, argumentation on the denial, where it is clear why the Supreme Court accepts one appeal and doesn't accept another appeal. We also heard arguments and criticism on Couper's decision, although in the Supreme Court we've also discussed what should be done after Couper's decision. And maybe we should refrain from giving arguments when refusing the claim. And where more case law exists, whether in the continental law or in the general law. So we came back to the yesterday's discussion, and we also discussed the consequences for the judge who fails to follow the common law. So it seems that we have discussed a lot, but this is not true. I have no doubt that other presenters will give even more valuable thoughts or ideas, or will be thought-provoking. Therefore, it is my privilege to give the floor to my colleague Anders Eka, President of the Supreme Court of Sweden. My colleague is not only the President of the Supreme Court of Sweden, but also the President of the Network of the Presidents of the Supreme Judicial Courts of the EU. So it is my privilege to give the floor to you, my colleague.
Thank you so much, dear Madam President. Better like that. Thank you so much for that. And dear Madam President, dear colleagues and friends, first I would like to congratulate the Supreme Court and the university for organizing such an interesting conference here today and yesterday. And I will also like to congratulate the Supreme Court to the anniversary celebrated this year. Well, the title for my short intervention is Achieving Uniform Application of Law, the Swedish Experience. And I will try to give an overview of the tools that the Swedish legislation provides to obtain consistent practice and development of the law through precedents given by the Supreme Court. I think I have a few slides, yes. Well, that was that. Well, that's me. Well, first a few words about the Swedish court system in general. And let me also note that as you know, the Swedish and the Finnish system are quite similar. You will recognize a few things from the presentation by my dear colleague and friend from the Supreme Court of Finland yesterday. But as we all know, repetition is the mother of knowledge. Well, as you can see, the Swedish court system rests on two pillars. One pillar for the general courts and one for the administrative courts. The general court system consists of 48 district courts, 6 courts of appeal, and the Supreme Court. They deal with criminal and civil cases and certain other matters such as adoptions and appointment and guardians and things like that. The administrative court system consists of 12 administrative court, 4 administrative courts of appeal, and 1 sister court to us, the Supreme Administrative Court. Like the other Nordic countries, Sweden does not have a constitutional court. When constitutional issues arise regarding judicial review in individual cases, they are examined by the Supreme Court or the Supreme Administrative Court. And the Supreme Court is the final court of the general court system and thus the last instance for civil and criminal cases. The Supreme Court has about 100 employees, of which 16 are justices. Most employees work at the court's drafting division, with a total of approximately 60 people working there, 40 judge referees, some drafting law clerks and secretaries. As we heard from Professor Galic, it's clear that the main function for the Swedish Supreme Court, the function is not motivated by the parties' interests to receive a correct result in the case. That interest is provided through the handling at the district court and the Court of Appeal. The main task is instead to create guiding decisions to facilitate the uniform application of law, and to ensure that the court can focus its work on setting precedents. The Swedish procedural rules provides that, in general, an appeal must be granted leave to appeal in order to hear a case in full. There are 2 different grounds for leave to appeal. And this is the slide that I should have used earlier. But here is the criteria for leave to appeal. The first ground, which is the most important, of course, and which is the ground for 90% of the decisions to grant a leave to appeal, states that a leave to appeal may be granted if it's important for the guidance of the application of the law that the case is tried by the Supreme Court. We call it the dispensation of precedent. The second ground provides that leave to appeal may be granted if there are extraordinary reasons for re-examination of the case. This is usually called extraordinary dispensation and may be granted if there are grounds for relief for substantial defects, which may be the case if crucial new evidence has been discovered after the Court of Appeal's judgment, or if a grave procedural error has occurred in the lower courts. A decision to grant a leave to appeal can be limited to a part of a case or to a certain question in the case, and this is an option often used. The court decides to take up one issue and the rest of the case will rest, waiting for the outcome of the dispensated question. The review whether to grant leave to appeal can be said to be discretionary. A case can, apart from this discretionary review, the court can consider that on the one hand, this case contains an interesting question, but on the other hand, the case would be inappropriate for the court to hear in full. The case may, for example, be too comprehensive, or perhaps it is so that the interesting question is obscured by some other non-interesting questions in the case. Whether to grant leave to appeal or not is determined by 1 or 3 justices, depending on the difficulty of the case. It is sufficient with 1 justice if the question is simple and it is clear that there is no reason to grant a leave to appeal. A decision to grant a leave to appeal is always taken by a panel of 3 or 5 justices. And if a case has been granted leave to appeal, the final decision of the case is decided by 5 justices. And the cases are always prepared by the employees working at the drafting divisions, and they prepare and present the case to the justices. About 90% of all cases are tried by 1 justice, normally after an oral presentation. And those cases will end with a short decision saying that there are no grounds for leave to appeal. It's a sort of standardized formulation. And the remaining 10% will be dealt with more deeper, and in those 10% contains the cases where the court will create a precedent. And they are also decided upon an oral presentation from a judge referee. If a case has been granted a leave to appeal, the following procedure is normally a written one, where the parties send in their briefs, after which the case is decided. Sometimes there is an oral hearing, but those are quite rare. I think we usually have 25, 30 oral hearings a year. When trying a case in full, when a case has been granted a leave to appeal, the court consists, as I mentioned, of 5 justices. If, however, they, in their deliberation of the case, find that there may be reasons to overturn or deviate from a former president of the court, they can refer the case to a plenary session with all the 16 justices participating in the judgment. And this means that the precedents are not legally or formally binding for the lower courts, only for the Supreme Court. We are bound by our earlier precedents. But this is not really an issue because the precedents are respected thoroughly, and I think you can talk about a sort of de facto binding feeling that it's okay to deviate from a precedent, but you have, as we heard earlier, you have to present arguments for that. I would like to say a few words finally about something that we have worked with during the recent years. We have initiated a deeper dialogue. Let me see. Yeah, a deeper dialogue with what you might call the court's stakeholders. The Supreme Court, as I mentioned, grants a leave to appeal in only 2% of the appealed cases. That is a little bit more than 140, 150 cases a year. And the result of this is approximately 100 presidents every year. I think personally that is enough number, and I don't think that we in Sweden really have a discussion regarding uniformity. That is not really an issue. But the question that we have put to ourselves is, how do we know that we select the right cases? There is, of course, a lot of knowledge within the court. All the justices have specific expertise and knowledge regarding certain legal fields. And of great importance, of course, is the arguments presented by the parties when they apply for a leave to appeal. But still, are we sure that we concentrate our efforts to produce precedents to the relevant legal issues? This question has led us to arrange judicial practice seminars in various legal fields. For instance, regarding criminal law, we invite judges from first and second instance courts, defense lawyers, prosecutors, and representatives from the university. We ask them to give presentations of legal issues that they considered should be dealt with by the Supreme Court. Similar practice seminars are arranged in other legal fields, such as commercial law, insurance law, family law, environmental law, and so on. The results from these seminars are summarized and used in the court in its internal work and are important input in the process of selecting relevant cases. The seminars are also important occasions for a close and fruitful dialogue regarding current legal matters. So, I think my time is running out, so I have to stop here. Hopefully, there will be an opportunity to come back to these issues during the general discussion. Thank you for your attention.
Thank you, colleague. By his experience, the colleague has proved that it is not only about law, but also about the practice of interpreting the grounds for granting a leave to appeal. 90% of cassation decisions are taken to follow the public function. Several aspects that I've noticed is the grant of leave to appeal on a part of a case. In today's discussion, we are dealing with a proposal of having the extended panel of 5 rather than 3 judges, which is the case in Sweden. And we've heard that the judges of lower courts are not obligated to follow the case law of the Supreme Court, but the judges of the Supreme Court have to abide by these rules. And we've heard that 2% of cases are 2% of cases are accepted, and 100 of decisions are taken per year, which actually can be compared to 500 and 600 made in Lithuania. And how can we decide which issues should be brought before the Supreme Court? Different discussions are very useful for making that decision. And I would like to invite other colleagues and my friends from Estonia and Latvia. We have a joint Baltic network of judges of the Supreme Court, and we learn from each other very often. And I would like to give the floor to Mr. Igor Strupiš, President of the Supreme Court of Latvia, my best friend. I believe that the experience of Latvia is also useful for us. So, Igor, the floor is yours.
So, thank you, dear Madam President, dear colleagues. Congratulations from Latvian Supreme Court to your anniversary. But one of the best ways to celebrate is to work, as we know. So let's go on with our today's topics about how to ensure uniform application of law, or perhaps it's not necessary, as colleague Galic mentioned, to some extent at least. But my topic is instruments of the Supreme Court of Latvia in carrying out this function of the Cassation Court. I think I might have some slides. Basically, I could divide those instruments into several groups. The one is the principal instruments, which of course is rulings of the Supreme Court, which according to our procedural laws are to be taken into account by lower judges, but by any judges actually. But what does it mean to be taken into account? It's not like they are binding. No, they are not binding in the sense of common law legal system. It's more like it could be interpreted as they should be considered, which implies that, first of all, you can consider only what you know, so that they should be known, first of all, so each judge should know the case law, and then they can consider it. But they are not binding in strict sense. They are the starting point of departure from which the judge should start the adjudication process. But a judge may depart from this case law if he or she provides reasonable arguments why the departure took place. There have been a couple of disciplinary cases also when judge departed from case law without any explanation, and I think in those cases it wasn't even indicated. There was no indication if the judge knew about this case law, but our disciplinary committee went quite soft on those judges in these points. But I don't think it was quite right for the disciplinary committee to do it, because it's a job of a judge to argue, to explain why the decision or judgment is like this. But what I wanted to emphasize, that those disciplinary cases were not due to judges departing from case law, but the grounds for disciplinary cases were that the judges did not argue, they did not reason why they did it. Not departure as such, but departure without reason, without giving reason. So this is the first and the big instrument which is used daily, and it's roughly 300 judgments and decisions per year which Supreme Court gives out. As you see on the screen, it's for 3-year period, so 900 per 3 years, 300 per year in average. And regarding this part, especially important, particularly important judgments and decisions are regarded those which are made by an extended panel. And what does it mean? It means that if usually the cases are adjudicated in composition panels by 3 judges of the Supreme Court, but if those 3 judges cannot get a uniform decision regarding the case, then the case goes to extended panel. Also, if those 3 judges decide that they would depart from the previous case law, then also a case goes to extended panel. It's also a possibility. And of course, it's a general understanding, and it's usually more correct than not. More often correct than not, that more brain matter gives a better result. You know, if it's adjudicated by say 9 or 15 judges, usually the result carries more authority for legal community. This is the main thing. Then there are a couple of, I would call them auxiliary things, auxiliary instruments which we employ to carry this case law over to our colleagues in lower instances and over to attorneys, prosecutors, and so on, all the participants who meet within a courtroom. One of this is we can do make case law also in plenum, which is the General Assembly, plenary assembly of all the Supreme Court judges. This is historically, this instrument was very, very important up until some 20 years ago, maybe, when the Constitutional Court decided that it should not be so important because it was inherited from the Soviet times, and it was written in the law by I think it was 2002, around that time, that the decisions of plenum are binding, and this really is too much for the court system, because it can be translated as already as introducing courts into legislation, and we didn't want to go that path. And I think for the court it's more important to give a little flexibility, because really too much uniformity can really make things blunt and stale, you know. And I agree with. There was this German legal philosopher and lawyer in 19th century, Rudolf Jering, whose theory said that the law and the rights of people develop in a battle, in conflicts, and that there should be some tension between different opinions also within the law, within the interpretation, because only this, through this you can get new solutions and adjust the law to the current needs of society. Currently, plenum has not made any rulings, any decisions regarding specific cases. There has been only one decision by plenum, by plenary assembly of the Supreme Court, and it was regarding the introduction of the electronic case in 2022. Because we saw that there was political pressure to introduce it as of a certain date, but it was obviously for everyone, if it was introduced at that technical level as it was prepared by that date, the court system would collapse or stop, at least stop, because it was not possible to carry everything over to electronic part. It technically was not ready. So the plenum came together. I convened the plenum, and we decided that until the technical solution gives courts reasonable grounds for normal work, by then, alongside with the electronic case, the old paper cases should be allowed in the interests of access to court and according to our constitution, section 92. So, but plenum is not involved in too much issues nowadays. A bit more. Another institution is involved, which is also provided by the law, and it is a general meeting of chamber. We have 3 chambers in the Supreme Court of Latvia: civil, criminal, and administrative. And our law gives a possibility for the chamber to decide on legal issues, to give interpretations on legal issues. The law is not specific about the procedure, how the questions come in and how it should be done. It's set out only as a general principle, but in practice, it's usually either judges of lower instances who send in questions. And sometimes it could be even people from outside court, or it could be also theoretical attorneys or litigants or whatever people who are involved in a case. And it's up to the President of the Supreme Court to decide, after consultations with the relevant department, to decide whether this really constitutes the issue of importance for uniform case law, and whether it cannot be resolved in any other way. And if we decide that it's important, then the general meeting of the chamber, all the judges within the chamber decide on this issue. It's not employed very often. It's more often in a civil chamber, civil law chamber. In other 2 chambers, I don't think there ever has been such a decision. But in civil chamber, it could 1 or 2 cases per year. It happens. And then the third part of the instruments are I would call them support instruments, and we do it basically in 2 ways. One is the compilation of case laws, which are prepared by our research department at the Supreme Court, mainly, sometimes by the counselors in the chambers too. And we are preparing these about 10 compilations per year on different topics which we find more important. We decide to work on those the relevant year. And of course, the other methodological assistance to lower court judges is the seminars, meetings, discussions, which also are ongoing regularly. This is about what we have. We also are discussing about possibilities to extend the ways on how we could improve the uniformity of application of law. We discussed preliminary rulings as one of the solutions, but we are quite conservative currently about this issue. And what bothers me, or rather what I don't have answers about, is, for instance, about those preliminary rulings, how it will impact the Supreme Court. First of all, workload. It's a big risk as I see it now, because the workload is high enough already. But the workload can go different ways, and this is, I think, a matter for analysis to try to project for the future, because it could be increase of workload in short term, but it could be decrease of workload in long term if the answers we are giving, they are not returning anymore through general procedure. So it's an issue we should really think about. It could reduce the workload actually in the long term. But currently I do not have this analysis, and I'm still tended to remain in my conservative position for the moment. Another issue, another important issue here, what I see is the quality of questions asked, because what happens if the question is formulated, say in the first instance, it comes to the Supreme Court, and the Supreme Court gives answer, and at the end, it was not the right question, and the case has been sent to wrong tracks, and how to get out of it afterwards. This is also an issue I have to think a lot about. You see, it's very often it's not the right answer that matters, it's the right question to be asked, which is much more important than the answer given. Basically, in short, yes, we have also discussed so-called pilot cases when there have been some situations where there are suddenly increase of cases of a specific category in the court of first instance. It could be, sometimes it's related to changes in legislation, the different cases, but there are 100 of very similar cases in the first instance. And the judges do not really know how to deal with one or another legal question. And we also tried to introduce some green corridor for those cases up to the Supreme Court. It didn't work quite well, partly because you know, when you have a problem, and you convene 3 lawyers to solve that problem turns into 10 problems. And if this is discussed not among 3 lawyers, but among hundreds of judges, then it becomes thousands of problems. So currently this project also is put on hold, and we solve this by seminars and informal discussions between judges in different instances. Of course, it does not give much legal certainty, because when the case comes to the Supreme Court, the Supreme Court is not bound by those consultations, of course, because the Supreme Court hasn't seen the case. It's just theoretical discussions on more or less hypothetical issues. And it depends very much what information a judge of a lower court has given to the Supreme Court, because context matters here. So in short, this is what we are doing and what we are trying to do in Latvia. Thank you.
Ačiū labai, kaip girdėjote, tikrai mes panašumų labai daug.
Thank you very much. As we have heard, there are many similarities binding us. Our laws also maintain the provision that judges have to align with the practice of the Supreme Court, but while it is binding on us, we can only refer to it. There's also a Senate there in Latvia, as well as consultations, a plenum and consultation that are non-existent in our country. So perhaps we will have such discussions in Latvia as well. Now, I'm sure we'll go back to the issue of consultations, and I'm sure when we will hear about the impartiality of judges, we will hear about that. I would now like to give the floor to a colleague from Estonia, Nele Sitam.
Okay.
So congratulations also from Estonia, and thank you for a wonderful dinner. It was something to remind us for a long time, so thank you a lot. So, something about Estonia. Estonia is a small country. Our population is only 1.3 million, and there are 256 judges in Estonia. 19 of them are working in the Supreme Court. Size of the country has its pros and cons. It's clear that the size of the population impacts the number of cases that are coming in, and the more you have different lawyers, different judges, the more you have different interpretations of law. So one can say it's easier for us in Estonia to guarantee uniform judicial practice. On the other hand, small number of judges means that differences in understanding the law are more prominent or distinctive. If we talk about different form of achieving consistent judicial practice, I would distinguish between three levels. First, uniform judicial practice in one chamber of the Supreme Court. There are 4 of them in Estonia, and I will come back to that. Civil, criminal, administrative, as well as constitutional review chamber. Probably every judge knows how hard it is to keep an eye on your own court practice, to be sure that there is no contradiction, even no hidden one. In case there is, at least in Estonia, judicial panel dealing with the case must refer the case to the full panel of this concrete chamber. For example, to the full panel, the 3 panel must refer the case to the full administrative law chamber. This guarantees that change in court practice has wider support, and this formal procedural step is a clear sign also for outsiders. Yes, there might be a change. As I understand, that's the same in Latvia. However, I would point here also out one unwritten practice administrative law chamber uses in its practice. So it's not used by other chambers. And I know I'm a little bit provoking, as I'm sure that at least some of you, maybe even half of you, put this practice under question, bearing in mind the principle of confidentiality of deliberations. Namely, administrative law chamber has a practice that after the judgment is made by a concrete panel, votes have been counted, text has been written down, and all the judges in the panel have agreed with the text. The judgment, or the project of the judgment, is sent to linguistic correction, and, nota bene, also to the whole chamber. So, before the judgment gets signatures and is made public, the whole chamber has the opportunity to read it. The main aim is that all members of the chamber are aware of our case law. However, there is unwritten rule that other members of the chamber, not belonging to this concrete panel, may also express their view and may refer that, in their opinion, there is contradiction with previous case law. It is clear that this unwritten practice presumes high mutual trust among judges, and you must be very diplomatically careful in commenting the judgment made by the panel. And of course, also in commenting, you must respect the independence of judges in the panel. And the panel is definitely not obliged anyway to react to comments or give additional reasons, etc. However, at least in an administrative law chamber, all judges have agreed with this practice, and it has been a useful tool in order to avoid contradictions with previous case law. Second level, uniform judicial practice in the whole highest court in Estonia. That's the case with Supreme Court. In Estonia, taking account our size, we often tend to have a principle all in one. So, as I said already, all courts of highest jurisdictions are assembled in one court, Estonian Supreme Court. We have civil, criminal, administrative, as well as constitutional review chamber. This one institution approach gives us additional mechanisms to guarantee uniform judicial practice. Firstly, every chamber has the possibility to so-called borrow judges from other chambers. Several cases include complex legal issues which may entail different questions from different branches of law. For example, criminal law case involves complex administrative or civil law issue. Tax law administrative case may presume deep knowledge in commercial code, etc. So there is a possibility to add judge from other chamber to the panel resolving the case. This not only guarantees high quality of the judgment due to extra expert knowledge in concrete area of law, but also helps to achieve uniform judicial practice between different chambers and branches of law. In addition, secondly, there is a possibility, or I would say rather obligation, to refer the case to special panel. Namely, when a panel that deals with a case deems it necessary to derogate in the interpretation of law from the latest opinion of another chamber, the case must be referred to a special panel. This special panel includes the Chief Justice of the court as the presiding judge, 2 justices from the so-called home chamber who dealt with the case, and 2 justices from this chamber whose opinion is put under the question. And of course, there is also a possibility to refer the case to the Supreme Court in bank or plenary, where all 19 judges are around the table. Third level, uniform judicial practice in the whole court system. There are different tools for that. Firstly, which is probably common to many countries, all judgments of the Supreme Court are annotated, and annotations are accessible on the webpage of the Supreme Court, and they are also accessible under these keywords we have, probably all courts have on their search mechanisms. Secondly, a quarterly summary of case law of the Supreme Court is prepared by the Supreme Court itself, and this is accessible on the webpage, and it is also distributed by email lists of different lawyers. Thirdly, training. Here I would like to point out 2 aspects. In addition to traditional training concentrating on concrete topics, the training program includes every year also roundtables for all judges of particular branch of law, for example, for all judges of civil law. And the topics of these roundtables are chosen by the judges themselves before roundtable. Every judge can propose and prepare a topic that might be relevant to all judges and concern some systematic issues. For example, practical problems handling evidence containing state secret, or practical problems related to hearing mentally ill persons in psychiatric hospitals, questions related to translation, diverging case law on concrete topics, etc. So roundtables offer opportunity to discuss in less formal way issues which are relevant to the whole court system. In addition, every year a training program for judges includes a training prepared by judges and advisors of the Supreme Court itself. And this is dedicated to overview of last year's most important cases of the Supreme Court. And it's like unwritten obligations for every chamber to find this judge who is ready to make this 1 or 2 day training. Fourthly and lastly, I would like to point here also out one practical solution used again by Administrative Law Chamber of the Supreme Court. Namely, the Supreme Court in Estonia also has the system of leave, and as there was discussion about percentages, only approximately, on average, 12% of cases get the leave, which are proceeded. The decision whether to give a leave or not to give a leave in a concrete case is taken by a panel consisting of 3 judges. Despite that, every week we have a meeting in Administrative Law Chamber where we look through and discuss a table consisting summaries of all cases from the last week where the decision to give a leave is taken. The table contains small summaries of cases. Through this, all the members and advisors of the Administrative Law Chamber know what cases have come in and what legal issues and how have been resolved by lower level courts. This discussion is particularly important for having clear, systematic, general overview of all cases coming in to the Supreme Court. It might be that a minor case that in principle should consider it as not being important enough and not worth of giving a leave may at some point of time become worth of giving a leave, as there are already 5, 10, 20 similar cases. Similar procedural mistakes as patterns or different and contradicting interpretations may emerge, etc. So, to conclude, Ronald Dworkin has argued that law is in a wider sense political, but he emphasized that law is not a matter of personal or partisan politics for judges. Dworkin refers to the chain of law. He compares judges to novelists who write a collective novel. So, in deciding a new case, each judge, similarly to a novelist in a chain, has to continue the story which was written before, and the texts of judicial decisions are connected to continuity, which he calls narrative continuity. It comes from the past, through the present, into the future. So, I wish for all of us success in writing this collective novel. Thank you.
Thank you very much. We can really learn a lot from Estonian colleagues because everything, all is in one, and this is something as a food for thought for our system. We have a larger share of population than Estonia, but it would still be beneficial for us. I think that this will inspire some discussions on the unification of case law and independence of judges. Nelly mentioned that when the draft decision is made, it is shared with other colleagues and colleagues can give notes. Similar things were made in Cuba case without the additional function. So I believe that we will return to such things. Irmantas will speak on that. Now, I would like to introduce my friend, Dr. Artūras Drukas, Chair of the Civil Cases Division of the Supreme Court. You don't have much time. We are lagging behind. We also will have to give the floor to Irmantas, and then we will have to leave time for discussion. Thank you, dear colleagues, members, participants of this conference. Well, I could end here. Well, it would be very easy. Well, I will skip the history. You will be able to see my slides if you take interest in them. I will move to the forms. It was very interesting for me to make this analysis, the forms of unifying case law. We do not understand how this unification works. This is our everyday life and work. We do not get deeper into that, and I saw that we really have a lot of forms of unifying case law, and in order to understand them better, we can categorize them into different groups. in order to better understand them, for example, according to the establishment in legal acts. And I took this as a criteria or procedural measures, other measures, technological measures. They can be classified differently. So I would like to start from the formal ways of unifying case law. And one of them is the selection of the cassation cases. How to approach this issue and which cassation appeals should be admitted in order to ensure the unity of the case law and to deal with the divergence of the case law. So first of all, we have to eliminate the divergence or deviation from case law. We had 3 events at the Supreme Court on the effectiveness of the selection process, and also the quality of preparing the appeal documents, and also drafting recommendations made by prosecutors and lawyers. So what are the challenges ahead of us and what we're dealing with in our division? It has already been mentioned today. Should we adopt into our practice a leave to appeal for a part of the case? This would take the burden off the cassation courts, which, for example, is dealing with hundreds of questions, and only one of them is relevant. We tend to deal with 100, but one which is most important is sometimes left out. I support the professor's opinion whether there is a need to provide substantiation for the refusal of a leave to appeal. And actually, nobody questions that in our case, because we don't have such an obligation to provide substantiation. And maybe we should do that actually and clearly define the problem, why we're denying a leave to appeal. And this would clearly define the limits of the cassation. Another issue is of the duration of dealing with the case. Is 3 months not too long? Or for example, the repetition of cassation appeals, sometimes we have 3 or 4 cassation appeals that are repeatedly made. And also the selection procedure. What about the algorithm? Another thing that other countries have is the extended panels, mixed panels with judges from different divisions. We have expertise of the judges dealing with cases, and also advisory professionals. We publish the final acts of the decisions, or we do not publish summaries. We publish summaries only when decisions are made by extended panels. And if we publish that, we do that in the bulletin of our court. And the training of judges is also the tool which contributes to the unification of the case law. Having the doctrine of precedent legal regulation has been amended on other forms of unifying case law. Therefore, we have semi-formal ways of unifying case law, which is the compilations of case law. Certainly, they do not make the case law, or reviews and analysis of EU courts and other international courts, and provision of information on the work of the Supreme Court to the public. Why are they called semi-formal? It is because the Supreme Court decides on which issues are of importance. Certainly, other courts can also make an advice on choosing the area of interest. And also, we have informal tools, and here many things can be considered in this category. So first of all, we have organizational measures to improve the algorithms and quality of the selection of and the appeal, and also the procedure for the preparation of the documentation of the appeal. Certainly, we all sometimes have the problem of human resources and financial resources. Sometimes we are considering the establishment of a separate department for the selection of appeals, but this is certainly related to some additional resources which we lack. We have regular discussions where conclusions are made and some decisions are taken by the judges. We would also like to have the ex-post evaluation of the case law of our court. And step by step, I hope we will be able to do that. We have the network of Lithuanian judges, where we deal with different issues related to the selection, to the distribution of cases. And this is a type of an advisory tool. And finally, we have quality standards for procedural documents, requirements for cassation appeals. We have the set of rules established by the Supreme Court, which is not compulsory but is guiding in our work. We also issue press releases. For 40% of cases, we prepare press releases which we publish to the public. And all other forms that we all know, including training seminars, conferences, discussions, and today's conference is a part of that. We can see that all those tools are very different. They have different weight, and they can be applied depending on the situation that we are in. Thank you.
Ačiū, Artūrai, jūs buvote tikrai efektyvus. Aš jau matau.
Thank you very much. Well, I already see that a question is for Professor Galic. Perhaps we should not motivate adopting those decisions in cassation cases. Well, this is just something to think about. But now I turn to Professor Irmantas Jarukaitis, who is, I think, will provoke further discussion. He is a judge at the Court of Justice of the European Union.
Thank you. I thank the organizers for the invitation. I congratulate you on the wonderful conference. I believe that we can make this conclusion, and I hope I will not make things worse. I also congratulate my colleagues with the anniversary. Well, I saw a sand clock, and I thought that this is a kind of a pressure for me. And as we've seen yesterday and today, life is full of challenges. You are being invited to the conference, but then you are told that you have 10 minutes. And then you are told that interpretation will be made during the conference. Therefore, you will have to speak slower. But if you agree to everything and refuse your making your presentation, you will not be given a similar presentation, given similar invitation in the future. When I was invited to this conference and I started thinking about my topic for discussion, I was inspired by Professor Halich's case in Hana. I decided on my topic. It is an interesting topic. We are speaking about the same principle of the rule of law. I will skip many things here. Yesterday we've covered a lot. On the one hand, we all agreed that similar cases should be dealt with in a similar way. We were speaking about the equality, legal certainty, and the importance of those principles. And as Professor Galich said, as a rule, for Article 6 of the Charter of the European Human Rights, I quoted a Tudor decision against Romania. This topic is very sensitive because there are diverging opinions on Zahin against Turkey. We can see from a dissenting opinion, we all agree on the principle on how Article 6 of the Charter should be of the Convention of the Human Rights should be interpreted. And actually there was a difference of opinion, 10 against 7. And there was another aspect which mentioned by the Constitutional Court. We have to deal with two aspects of a court and a judge. The need for self-governance of the courts in terms of finances and funding when we speak about courts in general. But when we speak about the independence of an individual judge, this is a different case. And the aspect of the fact of the independence of judges is very much reflected in the
90 tikriausiai procentų bylų bus apie
is reflected in the European Court on Human Rights and its decisions, which states that the judges and the courts should be protected from the intervention of other powers. And many things are suddenly decided internally, which cannot be seen externally. the European Legal Institute has published certain standards of the independence of the judiciary and the independence of judges, and dealt with the internal and external independence of judges, and also spoke about the undue influence of colleagues. And as I mentioned, yesterday we discussed that, and Professor Kūris and Nekrošius mentioned the decision of 206, which was analyzed in different perspectives, but in my case, an important well, we are not dealing with the different discussions and annual meetings, but when we speak about practice and compulsory nature of such practice, we need to understand that a case can be very different. 70 to 75 cases in our case are cases of prejudiciary and preliminary, and one of the measures that courts have in Han Invest case, we had 3 cases merged, and one of the instruments that the court has is the so-called DRD department. We can ask for an analysis, and a separate analysis, not a research, was made in that case on how national courts or domestic courts deal with this by using different instruments, ensuring the unity of case law. And it became clear that courts have different practices related to the judges and to the assistant judges. In some cases, assistant judges have the right to make an opinion if, for example, the panel or the chamber has a different vision on that case. Before moving to Han Invest decision, I will mention a very fresh Finnish case dealt with several years ago. It was a very telling situation. In the Court of Appeal, the case was given to the panel of 3 judges. The panel informed the litigants that the case will be decided in 1 month, and in 3 months it was not done. And in 3 months, this case was referred to the panel of 7 judges. And initially, the panel of 3 judges was having one position, and in the extended panel the position changed because the members of the previous position were in minority in the extended panel. The Finnish Supreme Court accepted an appeal in its entirety. And interestingly, there was a difference in opinion, and decided that the Court of Appeal did not infringe the regulation of the time. And one main argument was that it was provided for by law. The issue was new, no case law existed. and the majority of judges said that since there was no case law, extended panel should not have been called for hearing this case. And this actually led to the challenging of the right to impartiality. Certainly, the Strasbourg court did not see any infringement in that. Professor Galich has mentioned this case, a very interesting case, because we're speaking about the situation in case of similar cases of the rule of law of Poland and Hungary. National judges refer to us, the panels of 3 judges refer to us. I have in mind the court of second instance of Croatia. They had a very interesting mechanism aimed at ensuring the unity of the case law. And as Professor Galich has mentioned, this was the registrar judge that was appointed, and also a meeting was held of judges which had the rule of dealing with the case in abstracto. When Croatia was preparing for its accession to the EU, the European Commission saw this problem and indicated that, and Croatia agreed that this was a faulty system, but the system remained. And the problem is that the registrar judge and his or her powers are not defined in the law. And the situation is that the panel of judges hears the case. In all those 3 cases, the court decisions were signed, but according to the provisions, existing provisions, the case is heard when the copy of the decision is sent to the litigants. And the judge registrar has the right, after reading the decision, say that he does not agree with that decision and that the case should be reopened. And in all 3 cases, the situation was different. And those situations show the discretion of the registrar judge, because in one case, he pointed to the deviation, and in another case, the registrar actually does not register the decision, but waits for the decision in other 2 cases in order to say that there was a deviation and the decision cannot be accepted. And if the panel does not agree with the registrar judge, he or she has the right to refer to the head of the division in order to have the meeting with all the judges. Not only all the judges, but also professors and experts in certain fields. And I thought that maybe I should have put on this compulsory opinion on my slides, and it entailed a compulsory explanation of the rule, but this opinion is not compulsory to the Supreme Court. So the question was, how much is this mechanism in line with the aspect of internal independence of the judge and also the rights of the litigants, because the litigants are not aware of the existence of the registering judge and of his or her powers or his or her behavior. Advocate General did not see many problems there. the meeting was very similar to the prejudiciary proceedings, but the main argument was that the registered judge does not take the final decision, and the cause can be proved because the main aim is the unity of the case law. As you can see, the court decided differently, and
Vadinama teisės aiškinimo taisyklė ar ne 19 straipsnio, tai iš esmės du pagrindiniai argumentai, tai yra tai, kad tiek ŽTK 6 straipsnis, tiek 19 straipsnis įtvirtina tą reikalavimą būti iš anksto įtvirtintų.
Well, certainly there's a requirement to have the rule defined by law, and when this does not exist, this could be appealed in court. Only statutory establishment of the panel of judges can be given the right to deal with one or another case. The court ruled that the rights of the litigants were violated. In that case, because conclusion could be made from the Advocate General that the evaluation of the consequences and the interpretation of the law could have been separated, but this is not the case. And litigants also have the right to speak on the interpretation of the law. And the conclusion was made that all these mechanisms are in violation with the article of the Treaty on the European Union. I called it orbiter. I do not know whether this is orbiter. This is a rule for interpreting a law, and the court ruled that internal mechanisms can really exist, and referring of the case from a simple panel to the extended panel can exist in practice, but has to be defined by law. And certainly the violation was that the primary panel has already begun the consideration of this case. Last year, we had an unprecedented case when the so-called Quadrature du Net case was dealt with the Grand Chamber. There was no agreement. A new general was referred to, and a new general decided that the case will be dealt with the full court. So what are my conclusions? Well, in general, the judicial practice is or judicial case law is made by the decisions, and the rules that are applied within the court have to be statutory, and the cases need to be defined when the case can be referred to another panel. And the panel, which has already started dealing with the case, has the right to control this case. Thank you very much.
Ačiū labai, Irmantai, tikrai puikiai susidorojot, aš suprantu.
Thank you, Irmantas. You've managed perfectly well. I know that we are faced with a challenge of interpretation, because we do see that some consultations among the judges and the assistant judges are also very important in the in ensuring a uniform application of law. And so then we are left to deal with the question as to the impartiality of judges. and their independence. I know that the Dutch have some very interesting experience. Maybe Martin will be able to share with us with the experience of theirs. So, colleagues, Dutch colleagues, if I understand it correctly, Martin, please correct if I'm wrong. Whenever a case is assigned for a panel of judges, the case and the issues within it are discussed in a meeting or assembly of judges, and where all the judges can express their position as to how it should be dealt with, what kind of approach should be taken. And so, as far as I know, this is being questioned now at the European Court of Human Rights. Maybe Martin will be later to comment on that. But let me return to the question for Professor. We must argue the judgments in cassation cases. Professor, perhaps you could reflect more on the independence of judges and the means to ensure greater independence of judges. We would be more than happy to listen to your insights.
Independence of judges in what context exactly?
Sorry?
In what context exactly?
Just your general observations, but...
as I said, I mean, there is internal and external independence of judges, and we've heard a lot about it. And from what I tried to present in my speech, that is, it doesn't really matter to make precedents binding or non-binding, because they will be followed, they will be eagerly followed by lower courts anyway. So this is not important in my view. In my view, what is important is to ensure that the judges will, as the Latvian Supreme Court judge stated, know the case law. If they depart, they should provide reasons for that. That is Article 6 European Court of Human Rights requirement. And that is a lot. And of course, this extra reason is important, because departure from case law should never be intended to be a one-time event. It should be intended as an attempt to change the case law. Of course, it's logical. If you want to convince your colleagues, you need to try harder. You need to make extra effort. That's how it works. So one thing, knowing the importance of knowing the case law, finding the case law, studying the case law, and then that's enough. You don't need it binding. The other problem is, because I said, what's the most usual reason that the judges don't follow? They don't follow when they don't know it. There is one other case. They don't follow because they don't know how to follow, because there is a problem in quality, consistency, and how understandable the judgment of the upper court, Supreme Court, is. And here we come to the issue of importance of quality and extra work, which should be extra effort by the Supreme Court, which is also combined with the selection of cases, so the lower caseload. So, and that's, in my opinion, that is perfectly enough. And then, as I said, I think in most civil law countries, they don't bind lower court judges, but it's not really necessary. It will be followed. It's important how it is followed, and the distinguishing technique, and so forth. For the Supreme Court and its own case law, I think the instruments which were discussed, extended channels, chambers, plenary sessions, that is important. But it's important, I think, that the case is referred to the plenary session before it is already adopted. So the system of the veto right is really flawed.
And maybe I will specify a little bit questions. So Artūras Driukas mentioned that we are discussing whether we should motivate the acceptance of the cassation appeal, indicating the legal question. So because you provided argumentation that it's not so easy to provide argumentation for the non-acceptance. But how about when you accept the cassation complaint? What do you think? Whether there is some rationale to provide argumentation?
Oh, yeah, I mean, first, the lawyer trying to get access, leave to appeal, should formulate the legal question which is challenged in a concise manner, and there could be more of this, 10, 20, and then usually the Supreme Court, I think, will not allow appeal on all these points. Of course, in the decision granting leave to appeal, I think there should be a statement: the appeal is granted for the answer to the following question. I think that's how it's done in Slovenia. I think that there has not been any issue with that. But of course, formulation of questions, reformulation of questions, which is also possible, but it should remain within the ambit is crucial.
May I comment? Yes. In Estonia, we do not substantiate why did you give a leave, but it's more and more going practice that if we accept the case and now we send the letters to the parties, so now you have an opportunity to say out loud what you want to say about that, then we always try to point out for Supreme Court the issue is interpretation of concrete this and that norm. Please concentrate, you can say whatever you want, but please also concentrate on this particular issue. And it has been more and more used in our practice, and actually lawyers are really satisfied with this, because they don't start to write tens of pages of letters for us. They know what is the reason through this, why did we give a leave, and what is the issue on the table. And when we have oral hearings, we always send before, during the session, we will concentrate on this issue, on this issue, on this issue. Please prepare for that. So it's clear for the parties what is about. We don't want to talk about this and this and these issues, but the aim is to concentrate on these issues. So it's a matter of practice. Thank you.
In any case, you provide some reason for the acceptance, because in Lithuania we have only one sentence: just we accept cassation appeal, and that's all.
Yes, we don't give any reasons when we make a resolution, formal resolution. Yes, we accept the case. No, that's just one sentence. But later on during the process, when we communicate with parties, then through this they get the understanding what the case is all about.
It's to some extent so-called informal way to provide the direction. Artūrai, tai prašau.
Labai trumpai. Aš tik pasakysiu.
Well, I'll be brief. Perhaps our guests are unaware that by refusing to accept a cassation appeal, we have to briefly frame our reasoning. Those who want to have an in-depth argumentation, usually they fall within the judgments of the cases. Well, I don't see any added value to giving such in-depth reasons, because the other party to the case has not been heard in making that decision. So I do favor the opinion that it is sufficient to outline the legal basis for making that decision, because the author of cassation is aware of the reasons, and the lawyer must also outline the basis for granting the decision in the cassation case. But we're also compiling an internal bulletin where the selection panel indicates the legal basis on which a cassation judgment was made. Are we always doing that quite qualitatively, and we identify very specifically the legal issue that's a matter of practice. Well, we're not perfectly satisfied with how we're doing this internally, but if we do have an agreement that we have to indicate those arguments within the judgment in the cassation case, I believe that would serve our cause of improving further developments in the case. And perhaps, Andres, would you like to add something?
The question of giving some explanation for. Usually, as a principle, we do not motivate our decision to give a leave to appeal. But as I mentioned, we have a system often used that we pick up just a part of the case. We have the possibility to grant leave to appeal regarding a certain question. And then, of course, we have to formulate that question. For instance, saying that we are granting a leave to appeal regarding the question of burden of proof, and that the question is, does the burden of proof regarding a certain issue in this case lay on the claimant or on the other party? And then we pick that part up and we say the question of leave to appeal for the rest of the case will be dealt by later. So then, of course, the parties know exactly what the question is. But if you grant leave to appeal for the whole case, then it's often clear why the question of the principal issue is often very clear for the parties.
Thank you, Anders. Irmantai, jūs norėtumėte komentuoti?
Aš trumpai, aš tik norėjau pritart skyriaus pirmininkui, kad iš tikrųjų tas motyvavimas.
Well, I would just like to agree in saying that it's up to the needs of the court, because if you grant the appeal, then I guess you agree with the doubts conveyed in the cassation claim. And so any further reasoning must be then taken by the litigants in the next phase. Well, thank you, Irmantas. Perhaps now let's turn to the audience. We've covered a number of different issues, so I would now encourage you to raise your hand and give your own questions.
Concerning deliberations in the entire division.
Well, maybe I have an interesting topic for debate that is one of the mechanisms for achieving uniformity of decision within the Supreme Court, which is under fire in a case pending in Strasbourg. It's a method that we have been using for decades. So if Strasbourg would rule that it is in violation of the Constitution, it would bring about a revolution in our practice. At least it should. Let me just explain that we have 3 chambers, and each chamber consists of, let's say, 10 to 12 judges at the Supreme Court. And a case is decided in the end by a panel of 3 or 5 out of those 12. And the case, as you mentioned already, if a case is brought to the Supreme Court, it's distributed to the correct chamber and is then discussed among those 12 judges. And they can all bring in their arguments in the discussion. But in the end of the day, 3 or 5 out of the 10 or 12 will decide and will draft the opinion, the judgment. But the outsiders, what we call the reserve judges, so to speak, may also bring in their views. But they're not binding. They're just by way of expertise, extra expertise. And this practice, which we find very attractive, because it guarantees that within each chamber everybody is aware of all the cases and can avoid divergence of case law, is now under fire. The argument being that, well, for instance, the argument, I'm not sure whether it holds, but the argument, I think, is it's a violation of Article 6 because you have participation of judges who are not, in the end of the day, rendering the decision. And the argument is then there's a similarity brought, well, is there enough clarity about, for instance, if a party would like to recuse one of the judges, one of the reserve judges. I admit that that is not regulated quite well in our statute, but there is a protocol that says to all parties, if you have an argument to recuse the reserve judge, you can bring forward it and that judge will step aside. So we thought that in the end of the day we would live up to the standards of Article 6 of the Human Rights Convention. But you could say it's not in the statute, it's a practice that works well, and we'll have to see whether Strasbourg allows us to continue with a practice that we think works, where nobody is really harmed. Everybody has all the rights that Article 6 awards to him or her. The nasty thing is that you could say it's not well written out. I myself am a little bit skeptical about that argument, because you can put everything on paper, but if people really live up to what's on paper, you have to trust them to a certain extent. And unfortunately, I think this case represents the growing trend in the Netherlands, and perhaps in many other countries, that even if a judge says, I act in conformity with my conscience and with all the rules, that's not sufficient. You have to show a protocol that says that you do this, and then you have to make 6 boxes, and in each box you have to tick the box and say, yes, I was not bribed, no, I don't have a vacation house that is being paid by one of the litigants, and I can show this because this is the full, my yearly tax income sheet. Well, I'm trying, of course, exaggerating, but my fear is that whatever the court in Strasbourg will say is adding and not taking away distrust by piling up additional safeguards and thresholds before we believe that judges are doing what they should do, that is, within a chamber, come to the right decision. And who cares about who is saying what? In the end of the day, what matters is the decision that goes out, written by 3 judges, assisted by their colleagues. Well, that's the point that's at stake in Strasbourg. Thank you.
Thank you very much, Martin. Iš tiesų, panašu.
Well, it seems that we will have to organize many more conferences on this topic, because, as Martin has said, if the European Court of Human Rights decides that this is an infringement, the Netherlands will have a revolution that will change the practice that existed for decades. I believe that the Netherlands would like to discuss on that matter what to do next, because, as Martin said, this is a wonderful instrument. Those internal consultations and advisory opinions are very important in the unification of judicial practice. And if we consider those tools as infringements to the European Convention of Human Rights, then it means that the whole system needs to be overturned. Therefore, we will be looking forward to the decision of the European Court of Human Rights, and we will have to have a conference on that finally, no matter what the decision of the court is.
Sorry, Professor, can you speak to microphone?
I can stand up and
it's
for recording. Okay, thank you so much, and thank you so much for the comment about internal consultation.
Oh, can you speak to microphone, because interpreters, they are not can hear you.
I just wanted to yet again thank you for the prior comment about internal consultation, because it does bring forth the tension about transparency. And so I have one question and one comment to share. And one question, of course, is to the colleague from Estonia who said that judges can specify the particular question for lawyers to address. That's going to be on appeal for secession review. And I guess what my concern is whether or not lawyers in those cases, parties in those cases, have a chance to respond to the judicial reformulation of that question, because again, it really relates to both the due process rights of the litigant party and also to transparency. So that's my first question. And then my second really is a comment, and I just wanted to share what is going on with the Supreme Court in the United States today and the concern with transparency. increasingly there's been a concern that judges on the Supreme Court are deciding cases based on what's called a shadow docket. And I don't know how many of you have heard of this, but essentially this is cases that come up before the Supreme Court based on emergency petitions. And because of the theoretical emergency nature of these petitions, the Supreme Court has increasingly decided cases on the merits, not on the procedure of whether or not this case should be heard or not, but rather on the merits without any opinion. And the Trump administration actually has increasingly gone to the Supreme Court on very substantive meritorious cases, but based on emergency petition, and is able to get decisions heard without opinions. And so right now there's a huge controversy and conversation about shadow dockets. And I guess I just wanted to highlight this for the court, and maybe perhaps it is a question as to whether or not there are emergency routes that will bring cases before the Supreme Court and evade the normal route of transparency and formal opinion writing.
Yes, short answer, yes, of course. This is, I would say, an open question. They can say everything about the case, what they consider to be important, but we draw their attention that, in opinion of the Supreme Court of Estonia, in that particular case, there is an issue of, like it was referred to, burden of proof, or we refer the particular attention of the Supreme Court will be on this particular article of commercial code, how to interpret in a concrete case. Sometimes we tend even to refer that, what do you think if it could be interpreted in a way like that? What is your opinion on that? So make even references, so what are the possibilities of different, whether it's particular like a piece of paper is a document, can be considered as an administrative act or not. What do you consider about that? So it's, yes, this is open question, so it's not closed door, I would say, yes.
Thank you very much, Nela. So,
well, we are running 10 minutes late. We could discuss at length, but it is time for us to conclude, and therefore I would like to conclude this conference. Unfortunately, we don't have much time for our discussions. I would like to thank my colleagues, professors who took part in this conference and shared their experience and insights. I would like to thank the presidents of the Supreme Courts of foreign countries who actually accepted our invitation and agreed to share their views. And I also thank the audience who were patient and stayed until the end of this conference. I would like to thank my partners. So first of all, the Faculty of Law of Vilnius University that took the financial burden for this conference and also was responsible for some administrative issues. I also would like to thank the Parliament of the Republic of Lithuania because we are hosted by the Parliament, and we also have been given with all the necessary support from the Lithuanian Parliament, including the interpreters. I would like to thank the interpreters. I would like to thank the Ministry of Justice that contributed to the organization of this conference and took care of our coffee breaks and lunch break. And I would like to thank our court colleagues, judges of the court who actually contributed to the success of this conference. So, Justina, all the applause goes to you. Thank you very much. If I forgot to thank you in any way, please forgive me. I will do it on some other occasion personally. So I wish you all the success, and we will see you in other conferences.